Hi everybody, welcome to another episode of Ask Me Anything with me, Yaasha Sabba, at Sky Unlimited Legal Advisory. That's skyunlimited.law. We're going to answer your estate planning, asset protection, probate questions today. The first question of the day, it came from a young daughter of a mother. So she's saying, my mother changed the trustee of her living trust from one child to another child. There are 4 siblings, and the one who's now the trustee refuses to share information about the estate with her 3 other siblings. So it sounds like this is this person's sister. My mom has dementia and is now living with her, with the trustee, the sibling. Are we entitled to a copy of the trust and or any other estate information while my mom is still living? How do we get a copy of the trust? It's very interesting. First off, your mom is still alive. So this trust is still technically revocable by your mom if she has capacity. The fact that your mom has dementia doesn't mean that she's not in control or in charge. It just means she has a diagnosis. And as we know with dementia, sometimes there are good days, sometimes there are bad days. Sometimes the disease gets worse and our loved ones are totally gone. They're like adult children. They don't even know who they are, why they're here, that kind of stuff. At that point in time, they are legally incapacitated. But I can't tell you right now whether your mom has capacity or not. Either way, the moment your mom becomes incapacitated, somebody else will step up to be the trustee. And it sounds like your mom has already appointed somebody else to be the trustee. It sounds like she probably is incapacitated, that trustee is now stepping up and taking over your mom's role as trustee of her own trust. And it is now that trustees, whichever of your siblings it is, it doesn't matter who, whether it's your siblings or anybody else, when the moment you're a trustee, you have a fiduciary duty to take care of the beneficiaries, to manage the assets in the trust on behalf of the beneficiaries. Now, maybe all 4 of your siblings are the beneficiaries of this trust if and when something happens to your mom. But for now, your mom is still alive. She is the primary beneficiary, not you and your siblings. So because your mom is still alive and this is her trust, nobody is entitled to a copy of the trust. And whoever is the trustee has a fiduciary duty to your mother. They have an obligation, a duty of loyalty, a duty of confidentiality to your mother. So no, you don't get a copy of the trust while your mom is still alive, because that trustee has a duty to protect your mother and to keep her affairs private. Trusts are private documents. They are not public documents. The only time you ever get word that this trust exists, other than the fact that your mom has told you it exists, you know your mom has done an estate plan and she's done the smart move of building a trust because now her assets are in a trust taking care of her with somebody else in charge acting as her fiduciary. So that's a very good thing. But now she has dementia, and I'm sorry to hear that your mom has dementia. That sucks. But she does have someone in charge taking care of her. And maybe it used to be you, maybe it used to be another sibling. And then later in life, she said, you know what? I don't trust you or that other sibling to handle my affairs the right way. I'm going to put another one of my kids in charge. That's what she did. So now she's living with that child, and that child is managing the trust assets. Now, you don't need to worry. If you think that child is managing the assets in a wrong way, someday you might have a claim. You might be able to say, hey, bro or sis, I mean, remember, this is your family. I think you messed things up and you manage these assets the wrong way. Or sometimes, yeah, hey, bro or sis, you're taking money from the trust, from mom, and putting it in your own pocket. That is a breach of your fiduciary duty. This kind of stuff, you'll never be able to know precisely what's actually happening because a trust document is private unless you have some kind of proof or evidence that a trustee is violating their fiduciary duty on behalf of the beneficiary. There's really no way that you're ever going to get a copy of this trust. The whole reason for this is because trusts are meant to be private documents, and trustees have fiduciary duties only to the beneficiaries that they're taking care of. Now, if you are a remainder beneficiary in this trust, after your mom passes, you are and the rest of your siblings are beneficiaries. You are what we call remainder beneficiaries. Your mom is the primary beneficiary. You still have rights, and the trustee still owes you duties as well. such as if your mom's trust says, use all these assets to take care of me, and then when I pass, all these assets shall be held in trust for the beneficiaries to have income for their education or whatever, for example, then it is up to the trustee to make sure they're not squandering the assets. If it's not being used for mom, great, but they still have a duty to preserve the assets, not only for mom, but also the remainder beneficiaries after mom's life. So there are some duties there, but that still doesn't mean you have a right to see the trust document, right? There's no legal requirement that even beneficiaries see a complete trust document. So here's what happens when mom passes away. When your mom passes away, whoever's the trustee of the trust, they have an obligation the moment the trust becomes irrevocable in the state of California. And every state has different rules on this. So if you're in another state, you need to let me know so I can put you in touch with an attorney who can tell you this stuff. But every state has their different rules. In California's rule is that the trustee has to send you notice that the trust even exists within 90 days. That is not a requirement that the trustee give you a copy of the trust declaration. It's just a one page letting them know, telling you that, hey, this trust exists. It was created by mom. I am the trustee. Here's the attorney representing me. This is where you can talk to. So this is us sending the letter out for people. And then you have a right to request a copy or excerpts of this trust. And sometimes the trustees, we encourage trustees, just go ahead and give the excerpts or a copy of the trust in advance. And then you basically have 60 days if you do get a copy. If you don't get a copy, I don't recall off the top of my head, it's like 6 months to a year to dispute the trust if you want to dispute the trust. Right? So that's one way that you get a copy. Usually, if you're a beneficiary of the trust, we do encourage the trustee to give a full copy of the trust to the beneficiaries because you are entitled to know your rights. In California, a notice has to go out to all the beneficiaries of the trust as well as the heirs. Now, is there a requirement under the law, even if you're a beneficiary, that you get a full copy of the trust? No, there's not. The requirement's only that you get notice of the trust, and maybe the trustee will give you excerpts if you request them, and excerpts as they relate to you. So even as a beneficiary, you're not entitled to a full copy of the trust. Isn't that crazy? The whole point of that is because we want to protect the privacy of a trust. Trusts are private documents. And yes, it does create these awkward situations where when you want a full copy of the trust, maybe you don't see or get everything, But as a beneficiary, you are entitled at a minimum to excerpts. You can demand the trustee give you excerpts of the trust as it relates to your beneficial interest. And usually when you're one of the primary beneficiaries after your mom passes away, the new primary beneficiaries will become you and the kids, if that's truly how the trust is designed. You're pretty much entitled. Excerpts would be everything because you want to know, okay, what are my rights in terms of how to change the trustees? What are the powers that the trustee has when it comes to managing the assets on my behalf? What is my beneficial interest? But sometimes we want to split out interests between all the siblings. Maybe mom created different subtrusts or different provisions for each one of you siblings, right? And maybe she wants each of those different provisions to be private. She could even say in the trust, this shall not be disclosed to anyone other than this sibling. Then the trustee has a fiduciary duty to follow your mom's wishes in the terms of the trust. So as you can see, it's very complex. It's not complex where it's hard, it's just complex where it's highly situational specific. There's no guarantees on whether or not you get a copy. But as of right now, with the information you gave me, mom has dementia, she's still alive. This trust is designed for her. The trustee owes a fiduciary duty to her and nobody else presently at the moment. There is a small fiduciary duty to the remainder beneficiaries, but that doesn't mean they are entitled to a copy of the trust. As of right now, the trust is still revocable by mom, so there's no legal obligation that the trustee even give notice to any heirs or any beneficiaries of a copy of the trust. It's a little tough situation. Maybe you have good intentions. Maybe you believe this trustee is not doing a good job. Maybe they're doing their job fine. They're just not good asset managers. They're not good money managers. Maybe they might be abusing mom in different ways. And there's all sorts of elder abuse, not physical abuse, but what we call elder abuse, where you're either taking money out of mom's pocket unfairly, or you're unduly influencing mom to do things that she normally wouldn't do if she was in the right mindset. When you see stuff like that, it's not necessarily about the trust. These are other issues that you can bring up through other legal avenues, saying this individual, not the fact that they're the trustee, but the fact that they are a caregiver to my mother and they are not doing the job the right way. that is when you can approach them and say, hey, this is a problem, and you need to either do this the right way, or I'm going to seek other legal remedies because I believe you're committing elder abuse, or I believe you're taking advantage. But unless you see them squandering mom's assets and you say this isn't necessarily taking care of mom, or you're not really helping mom for her needs, that's when you can start looking into deeper with another litigation attorney on whether or not there's a chance that this trustee is committing a breach of trust. And in those situations, there are legal remedies where you could potentially get excerpts or a copy of the trust, but it is difficult, and you are essentially suing your other sibling, creating family conflict. So here, my recommendation is don't create conflicts with your family members. Instead, show that you care about mom, take care of mom, and have everything that you do be about taking care of mom, and know that mom put this person in charge for a reason, because mom trusts this person and mom chose this person, and that is mom's prerogative. That's her right. And you can't change that without having either mom say, or without proving that whoever mom put in charge is actually breaching their fiduciary duty to mom. Okay. If you want to go deeper, please reach out to me, info@skyunlimited.law. This is our question for the week. As always, anytime you guys have questions, we do answer them here for free, just so that we can spread education to our community, as long as you're willing to let me answer it for free. You can always email us at info@skyunlimited.law. Follow us on YouTube, on LinkedIn, here on Facebook. And we're answering questions around estate planning, asset protection, tax planning, probate, anything that your heart desires around protecting your loved ones and assets and keeping you out of court and out of conflict. I'm here for you. My name's Yaasha Sabba. I'm signing off. Enjoy the rest of your week.